Okay, we are live, family. Let's see here. Okay, we'll do this here. Hold on one second. Let's get this right. Alright. Okay, here we go. Okay, welcome, family. Thanks for showing up here today. Appreciate you. Um, have some very valuable information here, and we are going to first start it out as always with a song here, and give a little bit more people time to come in here. All right. So let's kick it off with a classic. Live, by the way. Live. Some people got to have it. Well, some people really need it. You do things, do things. Well, you wanna do things, good things. All about cash money. People will steal from their mothers. People will rob their brothers. People can't even know the street. Because they'll never know what the world is gonna be. Gonna be, oh, me great. Almighty God, welcome. Come out, the people will lie, they will see. People don't care who they hurt or be. A woman will celebrate just by that. There's a lot of ways. But me great. Almighty God, yeah, listen to me. My name is a riddle of evil. Anything to some people. Well, brother, can you start down? Brother, get off the people out of the town. No good, no good, no good. Got to tell them I'm really lay down, lay down. Give it up, give it up, give it up, give it up. Every Monday is the root of all evil. Money thing. Some people shout me if they go. A brother to his man to die. Money can never be your mind. Keep it going, keep it going, keep it going, y'all. Yeah. Oh, awesome, awesome. Thanks to that was the OJs and Daryl Hall live, family, and a classic. And for the love of money, let me tell you about it. We all know about it. We have people who do anything for money. You know, witches and warlocks are out here amongst this family, and it's part of life because this is a battlefield, right? And we have opponents. But it's our job and responsibility to be prepared so we can defend the attacks coming from these witches and warlocks, right? Because they're casting spells. They're casting spells, and we've been a target. We're food, family. You know, we have to call it as it is. We have been food, and everyone's been benefiting off of us. And but today we heard of the expression, the replacement theory. Okay, now that replacement theory applies to us, family. When I mean us, I'm talking about, you know, the real Americans, and that means we are the ones who have been here. We are the ones. Our ancestors are the ones that set up the infrastructure. But we have these, what I call sleeper cells, and the most dangerous ones, family, are the ones who look like us. Okay, because they're part of this program to replace us, and as they've already done it for the most part. And we are an endangered species. But for those of us left, we have a duty to change, to make a change, and create a future. Because failure to do so, family, we're going to be extinguished in the next 30 to 50 years. We're done. Okay? And this whole term that these witches and warlocks created, African American, in 1987, will become true 50 years in the future. Why? Because these African sleeper cells among us who are coming, who are sitting here, and oh my God, they are good, and they're everywhere. And one of the most famous ones, Joy Reid, she's on television. All right, and they're speaking for us, and they're becoming judges in the Supreme Court, and they're getting other nominees, and they're all around us, family. And in the next 50 years, the slave fiction will become true. Because now they have real Africans who are the real African Americans, and then they'll be able to actually, then they'll be able to tie their African names, because they're taking our names, but they'll be able to tie their African names back in history to link it all up, family. That's what's going on. And these type of sleeper cells, and you have others coming across the border today. Yeah, not only the Africans are crossing the border right now, we have Eastern Europeans, we have, you know, Afghans, and the other people coming over from where Russia's beefing with that other nation over there. They're coming over, but at the end of it, family, you know who's going to come over at the end? Who's actually controlling this? The Chinese. Many of these foreign sleeper cell Africans are spies for the Chinese. All right, so if we don't get our act together, we're done. And right now, they're in our cipher, interested in knowing our family history. For what purpose? To take it. Take what? Well,
I did previous builds. The one with the about the property in the South Carolina, and then the family in Louisiana that they called heirs property. We hear this term heirs property. So let's get. I want the family to get this correct. Do not ever utter out of your mouth that you have heirs property. Heirs property is a status you do not want to be in, family, because heirs property is getting taken. Now, the documentary I showed in my presentation, I believe it was a couple years ago or last year, where we showed the property in South Carolina, Diamond Head, Hilton Head there, and remember the family, the Louisiana family in that documentary that lost their 400 plus acres because of the legal device they created to where they can get 20% of the heirs to sell their share, and then force an auction. That's what's going on with heirs property, family. Now, in that particular video, there was a lawyer in there, and he created a law which he thinks he's helping them, but he's not. But the law is to where if someone is going to try to buy the heirs property, they can't just buy it by having 20% of the heirs sell their share, right? All must agree. But the critical issue is they're not telling the heirs that their land, they have patented land. That's the term you want to use, family. You don't have heirs property, you have patented land. And after this presentation is going to become very clear as to why the term you use is important. Because heirs property have been targeted, right? And they're being taken via these forced auctions, right? And families are losing everything. So, and it's been a while, been over a month since I've done my last presentation. I've been, doing real world, stuff here, helping people get their patented lands. So, and that's what I do. That's the contribution that I'm making. And yeah, so, but we're going to first do some house cleaning here because it was brought to my attention that there's been some very disrespectful statements coming out. And again, family, these witches and warlocks come in, different sizes and shapes and colors, okay? But one thing about them, they're addicted to the camera. And that camera is a powerful drug. See, but remember, my job is to present evidence, right? And I gave everyone full disclosure of who I am. I gave pieces of my resume and my legal prowess, some of my cases. I gave full disclosure, family. So we have to be more prudent buyers. We don't just sit here and let someone tell us something without showing and proving anything. And when it comes to legal stuff, such as land patents, which is very sophisticated legal, information, never let anyone talk to you about that, because if they can't show you that they know the law and that they've actually done it, help people get ownership of the land patent, initiated lawsuits to claim land patents, that they are legal masters, you can't listen to what they're saying. And if they're not showing or proving, showing stuff, you can never listen, because then you'll be a victim, and then they'll target you, and they'll coming out of their mouth is ridiculous stuff. Then you believe it and you fall victim, and you can end up losing your inheritance. And so I need to point this out, right? Because it's very, very important. So we will start here with the little house cleaning before I get to my main presentation here about as the title states, the case of Jacob, witches and warlocks. who are after our land patents. Okay, but let's do a little house cleaning here and set the record straight. So I'm going to show this video of this individual, share with the family, and I already have everything set at the minute mark, and we're just going to show the pertinent portions of this individual's demonstration. All right, so we'll start with this one here. And okay, here we go here. We'll start with this one. So let me first share my screen first. Can't forget to do that. Let's start here. Share screen, share screen. Put this here, share. Okay, there we go. Looks like I'm sharing there, family. You can put a 1 in the chat if you can see this here. Okay. So we're going to start here with this.
Court case dismissals.
Fair use for educational purposes.
I'm gonna talk about court case dismissals, and then I'm gonna leave the rest for later. Let's talk about court case dismissals, because in all cases, court case dismissals aren't good. When you bring forth a case and they get dismissed, that's not good. If somebody brings a case against you and it gets dismissed, that's good. It seems like every case you niggas is bring forth get dismissed. Why is that? I went and pulled up, because you niggas, y'all said y'all know about land patents. You said you knew about land patents before me. Fine, let me go pull it up. I went and pulled up one of your cases concerning land patents. I did. Pulled up one of you niggas' cases concerning land patents. I sure did. Let me push this camera up a little bit so you all can see me a little bit better. I pulled up one of your cases concerning land patents. You was the only nigga in the history of land patents to lose a case concerning land patents. I pulled up the case because it's public information to see if you had won a case, because y'all said y'all knew about land patents. Although in the case it said land grants, I said, okay, I'll let them slide. Let me read the case. I just got a thumbs down. Fuck you too. I don't know what kind of show you think this is. Apparently there was a Moor in jail. And another Moor, his leader, attempted to get him locked up, taken out of jail using land grants. Okay. Only problem is he didn't know what the fuck a land patent was, because how he listed it on the actual lawsuit, there was no land patent or land grant with only 3 numbers. That's how I know you niggas don't know what you're talking about. The judge had no clue what you niggas was talking about. And guess what the judge did? He threw your motherfucking case out. Just like the rest of you niggas' cases. Thrown out by the wayside. If you niggas knew so much about land patents, ain't no motherfucking way you'd have so many people locked up. Now let me tell you how much you don't know.
Okay, stop it there. So this individual mentioned a law patent case that some Moor lost, but actually never showed us the case. Never gave us the case number. Okay, never showed the case, never gave the case number. So we don't know who this individual is referring to. I'd be interested in reading up on that case because this is what I do, and I haven't heard of any recent cases, be it 2022 or 2021, where it had to do with a land patent anywhere. But recent cases, I would love to see that case and get more information about that case. But let's go to the next little clip here from this individual here. I have everything set up, marked and set, full screen, and here we go.
But what these goofies are doing is getting you niggas to change your fucking birth certificate to some other shit. And while they get their shit changed and their friends get their shit changed to your shit, and then they going and looking at all these cases that's happening in the appealing court, and then they appealing cases via the appealing court. Most of these niggas ain't even in America. They're in fucking Asia because they're Asiatics. Most of them is sitting up in Asia. Got cronies over here in America filing fucking false paperwork via the appealing court, appealing decisions made on American Negro families and attempting to take land that way. But look at your name and say dismissed. I want to show y'all something.
Okay, now you got a little bit more specific. He's sitting over in Asia. So that could be me, family, that this individual is referring to. Right? So the individual said that there's some sitting over in Asia giving false paperwork to his cronies. And then the crony will then in turn take the false paperwork and file it at the appellate court. Just to paraphrase what this individual just said. Okay, well, first off, you can never just directly go to the appellate court to file anything. The appellate court is the appeals court, family. You must first have a case in the lower court, and usually, as I advise everyone, you always want to, when you initiate your lawsuit, you want to be in the Article 3 courts, which are the United States federal district courts. That's where you always want to file your lawsuits, family. Now, of course, the federal district courts are, you have either federal diversity jurisdiction or federal question jurisdiction. Now, true diversity is citizens from different states can sue each other for damages over $75,000 in the district court. Now, if you're in the same same state with the defendants, and the defendants are state agents and they violated your substantive constitutional rights, even though you're in the same state with those particular individuals, then you can still sue them in federal court under federal question jurisdiction. But now, if you're in the same state for, let's say, the land patent issue, right? So once you have ownership interest in the land patent, then that gives you standing to bring a lawsuit. But if the defendants who are controlling your land are in the same state, unfortunately, we can't use the federal courts. We have to use one of the if it's Louisiana, it'll be one of the judicial circuit courts in the parish, right, etc. But this individual just said, basically insinuating some more in Asia is giving false paperwork to his cronies, and the cronies are in turn filing in the appellate court. Just to go over procedure quick, you must first lose in the lower court. There must be a judicial judgment, final judgment, where you lost the case, and then you filed a notice of appeal in the appellate court. That's when you can go to the appellate court. You can just walk in there willy-nilly. Now, if this individual is referring to me giving false paperwork to my cronies, then, obviously this individual is all about pomp and circumstance and props and costumes. It's entertainment. Okay, so you're joking about me. It's not about me, because you can call me anything, you can say anything, you can misrepresent and lie on me. That's fine. But when it gets to a point to where you're giving out misleading information intentionally to prevent the family from getting remedy, then I have to come in and present this twisted, intended demonstration to prevent the family from getting remedy, then I have to show and prove, and I have to disclose this, because failure to keep, if I keep quiet, family, then I'm an accomplice. So once you cross the line and you started coming in and you're affecting people in the community from getting remedy, that's a problem. Now let's continue with this last segment here. Fair use for educational purposes only.
And I said, okay, I told you niggas not to move the goalposts, but the lead ringleader decided he was going to move the goalposts. So I decided I'd come on here tonight in an outfit, since people are clearly listening. First of all, let me just say this. I don't understand how y'all listen to niggas with perms anyway. But I ain't going to, you know what, yeah, I'm going to judge y'all for that. Ye innocent bystanders. Ain't no goddamn way I'm sitting here and listening to take a nigga serious with a hair so soft, silky, and free. I said, don't move the goalposts. That's exactly what was done. So I saw it. And I'm finna reveal it tonight. I got the first copy. Before y'all got the chance to take it to Staples, I got the first copy of it. The Moors Asia Attic playbook. I'm going to read it for the people tonight. We're going to get into it before I get into my subject matter, because I'm right sick of you niggas moving the goalposts. So I called it, that's right.
Oh, wait a minute. The family can't hear? Hold on a second here. Got a message that you can't hear. Hold on, let's make sure this should be screen sharing. Put on one in the chat if you can't hear it. We lost the sound, family? Hold on.
And I caught it.
Can we hear it?
Because you know you niggas love taking shit to Staples. This is because the more say that the Asiatic.
Put a one in the chat if you can hear it. Okay, perfect. Thanks, Boxing Empire. Thanks, Dry Bones. All right.
I found that little playbook. And yes, this is an official copy of the playbook. They hadn't took it to Staples yet, but I got a copy. It says, as you can see, they say official document, do not share. But I got my hands on a copy. And I'm finna read some of you niggas' playbook. I told you niggas not to move the goalposts. You know I know more than I said on that video when I told you not to move the goalposts. I got your name, your real age, your motherfucking coordinates, the whole 9 yards. I ain't gonna put that kind of information out, but I will put the playbook out. Now look at here. I ain't gonna read the whole book. I ain't gonna read the whole book. I'm just gonna read a few of the chapters in the book. You know, the Asiatic playbook. Please click like in here while I read these niggas' playbooks, because he's the only nigga I know that be flashing all kind of little shit on the screen like it's an official document, and there's some shit y'all niggas going when it printed out at Staples. I'm sick of you niggas printing shit out at Staples. Y'all know that, right? You niggas is the most book printing and PDF goddamn creating niggas ever. I brought up that case about just because I wanted to see who was all listening. I brought up the whole New Wabian case that's back open up here in Georgia where they killed that damn Navy SEAL guy, beheaded that Navy SEAL guy and killed his wife.
Okay, family, we'll stop it there. All right. So the individual said she has some secret Moorish playbook, and she managed to get her hands on some secret Moorish playbook. But let me just continue so you'll get full context, so you'll know, because she's
just to see it now. Y'all on here unfolding, unpacking the new obvious now. No, don't hide now. Don't try to free yourself now. Don't try to free yourself now. All you dug demounters. Don't try to free yourself now. More dug demounters. No, stay right there. Cause I'm like, well, y'all motherfucking ass. Stay right there. Y'all, let me tell y'all. Let me read some of the chapters. One of the chapters is called Aliens.
Okay, we can stop it right there. So I just wanted to get to this part so we'll get a fuller context as to what this individual is trying to do. So we noticed the individual said that she has some secret Moorish playbook, and some Moorish playbook insinuating that there's some Moorish agents working for, maybe, I don't know, some secret ghost dark entity, maybe the CIA, and they're coming into our cipher and trying to deceive us, get us locked up, etc. But now, so she showed a document in her hands, and now she's purporting to read chapters from it, but it's handwritten stuff in her hand. She didn't show the actual so-called official document and read from that. Now she's reading from something she wrote with her hand. Okay, now family, let's actually examine what was actually in her hand. What was that so-called official document? Moore's secret playbook. Well, you know how we do, family. We're not now. See, when it comes to these witches and warlocks, family, especially the sleeper cells, one thing about them that's easy to pick out. You just got to watch people's tendencies, their behavior. They think we are dumb as a box of rocks. For the most part, we are. We are. Okay? Yes. We have to admit that, family, because on the road to recovery is to admit that we have a problem. And this is what they take full advantage of. But some of us, we pay attention to the details. So when you're going to show something on a camera, we're going to look at exactly what you actually had in your hand to confirm whether or not it is some secret Moorish playbook. So that's exactly what I did, family. So I don't miss details, right? So we're going to look at what was actually in her hand. All right, so here it is. So let's zoom in on it. Zoom in on it. Zoom in on it. Zoom in on it. Okay, here we go. See at the top, official documents, right? Property of, then we got name, address, city, state, blank, right? You can all see that. Now, we have Virginia Accord. Virginia Accord. Not real clear so far what that is, right? Virginia Accord. Then we have a sticky stamp that says do not share, okay? And we got some writing to the left. And if you look real closely, it's a 201 North. And we got to the right side of the blue sticky stamp. Can't really make that out. Okay, that's fine. Okay, well, I took a shot from another angle. Let's look at the next piece of evidence here. Okay, let's blow this up so the family can see. Okay, so now, okay, Virginia Accord, right? So we have the 201 North to the left of the sticky stamp, and the right is clear now. It says room 12. Remember that, family. 201 North, room 12. So it looks like it could be an address. Let's go below it. Oh my God, what do we have here? Decedent estates, marriage license, firearms license. Well, what this tells me, with my legal mind, this seems like this is some court document, and specifically a probate court document. So what I did was I put in the name Virginia Accord. And let's keep going. Let's look at the third piece of evidence. And lo and behold, here, Virginia Accord here. Virginia Accord is a judge, family. Here's the name, position judge, probate court. And that's Georgia. That's to the left. That's Worth County, Georgia. Probate court, family. And here's the judge's name, Virginia Accord, judge. But there's more to corroborate this. Let's go to image number 4. Okay, so we get a little bit more information. So we see that it is the probate court department of the particular court, and we see Virginia Accord position judge. All right, now let's see if we can confirm that little 201 North, room 12, right? You got to still corroborate that. Here it is, 201 North. The main street was covered by the blue sticky stamp, but the room 12 was on the right. 201 North Main Street, room 12. We have an address matched with the document in her hand and the name of the judge, the probate judge, Virginia Accord. This is not some secret Moorish playbook, family. And finally, here's an image of who is Virginia Accord. This is Virginia Accord, the probate judge. Okay. You can see closely down at the bottom. It says here, let's look at it. This guy, Mr. Wood, was presented the Instructor of the Year award by Judge Virginia Accord, Chair of the Council of Probate Court of Judges of Georgia. And I have another image here. And here in her hand, so we see this here. Let's blow it up. Right there. Virginia Accord. You see that. We see the 201 North. You see the room 12. That's the address that we just confirmed. And look at the bottom. Descendants estates, marriage license, firearms license, birth and death records. This is a document to be filed in the probate court. No wonder why when she says she's reading chapters, she's reading some handwritten stuff that she prepared. This cannot be tolerated, family. We cannot allow these witches and warlocks to deceive us, to lie to us, because from their position, they think we are dumb as fuck. And they can get away with this, and we cannot buy this crap, family. This is clear fraud and deceit with willful, malicious intent to deceive. We keep this up. This is how these witches and warlocks take our inheritance. We're judged here by our works, family, our deeds, and we must be honorable. You have to be honorable. But it's when we see someone demonstrating and deceiving and lying to the family, no, we got to step out and call it out. Especially when it comes to land patents and inheritance, because every day, families are losing their properties, losing their inheritance, family. This is not a joke. So this will segue into the presentation, because I will never deceive you. I will never lie to you, family. I'll never disrespect you, or I would definitely never play you for a fool. But the opponent, whose mission is to replace us, this is the battlefield that we have to confront. But we have to make sure we can identify an attack and successfully defend the attack, family. Failure to do so, this is what can happen to you. Now, let me explain the thumbnail. The case of Jacob, Yakub. Jacob is a Latin name. The English translation of Jacob is James. Hence, the image of King James. But if we're not focused on King James, that particular Jacob, this Jacob is Jacob Loud. Mr. Jacob Loud. Loud. Sometimes the last name would be Land. Land. It's about his case and how he's a landlord, but his heirs recently lost their inheritance, family, due to sorcerers and witches and warlocks. So we're going to listen to this interview with the heir and descendant of Jacob Loud so we can understand what happened to this poor family here. And this is just it's an interview on NPR. We'll just be able to listen to it. And again, as always, at the end of the presentation, any information that the family wants that I presented today, reach out, email, and I'll send you whatever you need there. Here we go.
From NPR.
I was born in 1972. I am the 9th child of 11. A huge family.
Fred Wardlaw grew up in northwest Louisiana in a tiny town called Castor. About a mile from his parents' house was a big parcel of land that belonged to his extended family. A lot of his family had houses there.
It has rivers, little creeks. I grew up picking corn, picking peas, picking butter beans. It was a community, a very vibrant community.
Sometimes he'd walk from house to house to visit his relatives. Sometimes he'd go out into the woods to explore with his brothers and sisters.
My siblings and I could walk to a creek and walk down the creek and fish from this land.
Wardlaw says it was a pretty happy childhood.
We was poor, but we just didn't know we was poor.
But after high school, he was ready for something new.
Growing up in rural Louisiana as a young black man, and you're not open to the full world. You're kind of left out of what's going on around you.
So Fred joined the Army for a few years, lived in Texas, Korea, California, and he went to college. Eventually, he settled near Washington, D.C., and got a job as a systems analyst for a publishing company. His hometown of Castor, Louisiana, seemed a long way away, until some bad news.
She told us that we could possibly lose the land.
She meant the family's land, where Fred Wardlaw's grandparents had had their farms, where he had spent his childhood fishing and exploring the woods. That land, she said, was at risk.
It could be forced to be going to a sheriff sale. If it go into a sheriff sale, it's like an auction. Anybody can come buy it.
It didn't really make sense. There was no mortgage to pay off. There were no taxes that were owed. But his mother said none of that mattered.
My family, my mother, her siblings, some more cousins on our side, majority of the cousins on our side did not want to sell the land.
So who said you had to sell it then?
The court.
The court. Hello and welcome to Planet Money. I'm Keith Romer. And I'm Jacob Goldstein. Fred Wardlaw and his family didn't know it yet, but they had gotten caught up in a system of centuries-old laws that have long been used to take land from families, especially from black families. Today on the show, the lawyer who has spent his career trying to change those laws, and Fred Wardlaw's fight to save his family's land.
This message comes from NPR sponsor Intuit QuickBooks, dedicated to helping small businesses be more successful.
About movies, music, and more.
Fred Wardlaw is very interested in his family history. And in that history is the answer to why his family's land was about to be auctioned off.
His family first came to northwest Louisiana in the 19th century.
They were not born in Louisiana, they were brought.
Wardlaw's great-great-great-grandfather was a man named Jacob Loud.
He was born a slave in Virginia, but he was transported with the families of Scottish Methodist settlers, and that's how he ended up here.
Wardlaw thinks that was probably sometime in the mid-1850s. After the Civil War came and went, Jacob Loud and his wife Member were freed, and they began to make a life for themselves as farmers. Jacob and Member had 5 children, and in 1906, Jacob Loud established a legacy for all his descendants who would come after him.
Jacob Loud acquired 160 acres from a land grant by the government. It was the Homestead Act. A former slave and now a landowner.
Jacob Loud did not leave a will, so when he died, his land passed to his wife and children. Then his children had children, then those children had children, and so on.
So that's 1, 2, 3, 4, 5 generations?
When Fred Wardlaw was growing up, the living members of those 5 generations owned the land collectively. The legal term for this kind of ownership is heirs property. Heir, like the people who get your stuff when you die.
We didn't really understand the full legal definition of what heir property was. We just understood it to be that this land was for your family, and it's for everybody in the family.
The numbers are a little hazy, but something like half of black-owned land in the United States is held this way. It's held as heirs property. And so the way the law around heirs property works is really important.
Jacob Loud's 5 children each had a 1/5 stake in that family land. But it wasn't like one of the kids owned the northeast chunk and another one had the northwest chunk. They all owned all of the land together.
And so if one of Jacob Loud's children had wanted to sell his or her 1/5 ownership, it was not like there was some specific chunk of the land that they could sell. What they could sell was their 1/5 ownership stake in the whole thing, in the whole piece of land.
Or, and this is the key part, if they didn't think they could get a good price that way, they could go to a court and bring a particular kind of lawsuit called a partition action. Basically, ask the judge to find a way to either divide up the land fairly or to just sell all of it and divide up the proceeds according to how big a share each family member owned.
And that is what was happening to Fred Wardlaw's family land when he got that call from his mom back in 1999. Someone had brought a partition action that was putting the family's ownership of the land in jeopardy.
But according to the legal papers, the person who had brought that partition action in court was not part of the family. He wasn't related to Jacob Loud at all. He was a white man named W.G. Dowden.
We got this information kind of out of the blue. We just wasn't prepared for it.
Fred Wardlaw wanted to understand how this W.G. Dowden came to own a share in his family land. So he flew home to Louisiana, and he went to the Bienville Parish Courthouse to try to find out. In the clerk's office, he found shelf after shelf of old books that tracked all the land in the parish, all the way back to before even Jacob Loud acquired his 160 acres.
You go to this book for the parcel number of what his property is. It gives you all the past owners of this property. You get all the information, all the transactions that was connected to that property.
And there, in one of those musty old books, Fred Wardlaw found his answer. There was a deed of sale from June 30th, 1980. Wardlaw's great-uncle John had sold his 1/25th share of ownership to a pair of white men for $100. A couple months later, those men had turned around and sold that same interest to W.G. Dowden for $1,000.
The book didn't record why it had happened. Fred Wardlaw would later hear an old family story about how his great-uncle John had taken out a loan to buy some trucks. using his share of the loan as collateral, and then giving up that share when he couldn't pay the loan back. But it didn't really matter why. It only mattered that his great-uncle John had sold his share. According to the book at the parish clerk, that share had changed hands one last time in 1992, this time to a timber company called Timberland Services.
Fred Wardlaw's family hired a lawyer and went before a judge. They tried to propose a solution that would be fair to everyone. After all, Wardlaw's great-uncle John had only owned 4% of the land.
But whatever his interest was, maybe he could just lose his part. Maybe we could just extract his part and salvage the other.
This is a reasonable legal argument. The law says the court can physically divide up the land to resolve a lawsuit like this. The judge could have broken up the land into pieces that corresponded to everyone's share, including a little chunk of the land for the timber company.
But if part of the land has houses on it, and part of it is swamp, and part of it is timber, and part of it is farmland, how do you find a piece of land worth exactly 4% of the total? Mostly, judges do not want to insert themselves into such a messy process. The judge in Fred Wardlaw's case said, I can't divide up the land.
The courts wouldn't let us do that. They made us hold all of it together.
What the judge said was sell all of the land, not 4% of it, all of it, and split the proceeds among everybody who jointly owns the land. And so, after the judge made that ruling, the sheriff put a notice in the local paper, the Bienville Democrat, announcing that an auction to sell the land would take place in a month's time at the parish courthouse.
I was shocked. Personally, I was just shocked.
Coming up after the break, the lawyer who has spent decades trying to
property law casebook or treatise
property owners were facing. It was a little slow going at first.
the whole phenomenon of how these families were losing their property and how the law actually worked was literally not in a single property law casebook or treatise.
And yet he found that the amount of land lost by black families in the 20th century was immense. Black land ownership in America fell by about 60% between 1910 and 2000. People were run off their land by violence or frozen out by banks and government programs until their properties were foreclosed on, or forced off their land by auctions like the one that was coming for Fred Wardlaw's family land.
But despite all this, despite the fact that so much land owned by black people was held as heirs property, there was very little legal scholarship about the issue. So Mitchell realized that if he wanted better answers, he needed to stop looking in, law libraries and start reaching out to people who had firsthand experience of the system.
The cases that we all learned in law school and for generations of law students were totally unrepresentative of the broader phenomenon.
And the more Mitchell talked to people like Fred Wardlaw, people who owned land in this way, the more problems he heard about heirs property. The law made it really hard for heirs property owners to do the things that landowners do to build wealth, to make money by cutting down trees to sell timber, or to use land as collateral for a loan. A lot of times, families could only do those things if every single fractional owner agreed. And a lot of those fractional owners were really hard to find.
You often have distant relatives who are now living in Chicago or New York or Detroit or Los Angeles who had no idea that they are actually a part owner of this property back in Georgia.
And then there was the problem that Fred Wardlaw's family had run into in Louisiana. These forced sales of heirs' property land were happening all over the country. Mitchell says there was a perverse economic logic at work for African American families. If you were a black farmer in 1910, you were mostly only able to buy the farmland that no one else wanted. But as the country grew, a lot of that mediocre farmland started to become more valuable.
And so that serves as the impetus for these speculators and developers to try to do anything they can to get their hands on the property and to force the sale.
At some point, property developers realized that there was this flaw in the heirs property system, this incredible way for them to get these newly valuable properties for pennies on the dollar.
Typically what they do is they pick the weak link, and then they often target the out-of-state, very distant relative who's had no connection to the land.
Developer calls up that weak link and says, I'll give you $1,000 for this tiny share of land in some faraway state that maybe you didn't even know you owned.
And all they have to do is pick off one relative. And that one relative doesn't have to own a significant percentage.
So if I have 1/25th share of this ownership of this land, I can go to a judge and say, I want to cash out, and the judge will say, sure, we have to sell the whole property?
Yeah, you could have a 1/25th interest. You could have a 100th interest. You could have a 1/1,000,000th interest. You have the right to ask for that forced sale.
If you're a developer and you get to the forced sale, you're pretty much home free. First of all, it's an auction on the courthouse steps that's only been advertised in the legal classifieds of some local paper, so no one even knows about it. Second, even if they did, the rules say that no one is allowed to go inspect the land ahead of time, so any prospective buyer would have to buy it sight unseen.
And third, maybe the most important part, anyone who wants to buy the property has to pay 100% in cash. So in most cases, even if the family whose land is being sold wants to bid on their own property, they're not going to be able to get the money together to outbid the developer.
If you wanted to set up a system where property developers could buy families' land from them for next to nothing, it would be hard to set up a better system for doing it.
By 2001, Thomas Mitchell had become a law professor, and he wrote this big paper about how messed up the laws were around heirs property, that legal arrangement like Fred Wardlaw's family had with their land. Mitchell's paper also had some ideas for how to fix those laws, but he was not optimistic.
My initial thinking was that it was more likely than not that any reforms would not happen in my lifetime.
But in a classic case of right place, right time, some newspaper journalists at the Associated Press wrote a big expose on how heirs property owners were having their land taken away from them. And when they needed an expert to quote, they went to the guy who wrote the big paper about it, Thomas Mitchell.
That press attention got things going. The American Bar Association got in touch with Mitchell. So did this other big legal organization called the Uniform Law Commission. And they asked him and a few other lawyers who were working on this, what would a better version of the law around heirs property look like?
So Mitchell and his team got to work. They decided their dream version of the law should have three basic parts. Part one, if someone wants to sell their share of heirs property, instead of immediately going to an auction, what if courts first let the other shareholders have the option to buy out that person who wants to sell? What if Fred Wardlaw's family in Louisiana only had to buy out the timber company's tiny share of the land? Wouldn't that make it way easier for them to keep the land?
Part two, Mitchell and the others thought property is more than just money, and the law should reflect that. So courts in these cases should consider some of these non-monetary factors, the value of a family's history on the land, or the value of not having your home sold out from under you. Is it worth it to let someone cash out their share if someone else is going to end up homeless?
And then, part three, if the judge still decides that the best thing to do is to sell the land, don't make it a fire sale on the courthouse steps. Appoint a real estate broker to sell the land on the open market, just like any other property. At least let the family walk away with a good price for their land.
Law professors and other people in the legal community looked at this proposed law, and they were impressed. They thought it was a good idea, but they didn't think that old law was actually going to change.
Not because it was just. A lot of people conceded that it was unjust, but they said the law exists the way it exists because African Americans, heirs property owners, fundamentally lack economic and political power. And the law is going to serve the interests of those who are more powerful, including those who want to take the land from these African Americans.
Still, every few months, he would talk strategy with the other members of his team about how they could get this law on the books somewhere.
We were very intentional about thinking of where did we think we had the best chance, and then trying to make a pitch to important stakeholders, including those in the legislature in those states.
And eventually, slowly, Mitchell started to succeed. in 2011, the legal language that he and his team wrote up to fix the heirs property system, it actually became law in the state of Nevada. In 2012, Georgia passed a law based on Mitchell's work.
We were able to, in the, something like the first 5 years, we were able to get like one state a year.
After Georgia came Montana, Alabama, Connecticut, and as of today, Mitchell's version of the law has been adopted in 17 states all around the country.
8 of the 17 states are southern states, and I think you're talking about the group of states where there had been 3 to 4 decades of failure, and it's actually on this issue the southern states are leading the way, which I find remarkable.
But there are still 33 states that have not passed Mitchell's version of the law, including, notably, Louisiana, the state where Fred Wardlaw and his family were told by a judge that the land that had been in their family for almost 100 years had to be sold.
Louisiana has changed the law some since then. If you own less than a 20% share in heirs property, you can no longer get a judge to force the sale of the entire property. But all those other features of Thomas Mitchell's version of the law, they are not on the books in Louisiana. If you open up the legal classified section of a local paper, you will still see announcements for sheriff sales from partition actions.
Like the one in the Bienville Democrat that announced the sale of Fred Wardlaw's family land. When the day of the sale arrived, the property was put up for auction at the parish courthouse, and no one in Fred Wardlaw's family had enough money to put up a bid.
The timber company ended up buying the land. Some of the family members got the proceeds from what the land sold for. It was divided up, checks were sent out, but at the same time, you lost it. You lost everything. They tore down my grandfather's house. The new people that bought it out, they didn't want no dwelling, so they tore it down.
Fred Wardlaw still remembers the look on his aunt's faces after the property was sold.
Their dad had told them that this was going to be property that's going to be left in the family, and we lost it. It was about maintaining what you had, maintaining what Jacob had acquired for us, and here we have done lost it. Less than 100 years later, and it hurt. It hurt a lot of us.
Fred Wardlaw moved back to Louisiana a couple years ago to take care of his parents, and he sees a lot more of his family now.
I started organizing and talking with people and bringing families together and bringing my siblings together first, and then bringing my uncles and aunts and some cousins together.
He teaches them about the family's history, about how the land came down from Jacob Loud, who got a grant of 160 acres from the U.S. government in 1906, about how the family lost that land. And he teaches them about how to protect themselves from the legal system that let that happen.
I wanted to be able to educate them on what to do to fight back and to organize and start getting wills and start doing insurance and start organizing your family. Tell your family about your history. Tell your families about your land because it means a lot.
Fred Wardlaw is also thinking about trying to buy a little land for himself, to be able to leave something behind for the generations that come after him.
All right, there it is, family. And that's a tragedy. I mean, that will make a brass monkey cry, family. And this is the critical nature of what we're dealing with here, and it's sad, and it's just actually ignorance of not knowing the law, and unfortunately, the majority of the people do not know the law, and and this is the beauty of our ancestors, and this is why they set the system up hundreds of years ago, the patent system, and created the laws, because actually that family can actually get their land back. Now, if you notice through that entire interview with the lawyers, because first of all, the judge can't force sale of anything, but the one thing they never mentioned, and this is that family savior, they never mentioned that you have patented land. They never mentioned. They said they just threw around a word of land grant. It's not a land grant. Land grants were under either the British jurisdiction, the 13 colonies, those British land grants, or the Spanish land grants. The United States Federal Republic government created their own patent system based upon two acts, the Act of 1820 and the Homestead Act of 1862. Those are land patents. And they actually still own the land, family. They can actually easily get it. Now, let me show you the actual Jacob Loud land patent that is still active and valid. Now I downloaded it, but we're gonna go straight to the BLM site so we can see it. See, with these lawyers and these judges, lawyers are spies, family. It's a racket that's going on. They want you under the heirship umbrella because they created these legal devices to take it. That's the biggest racket going on. And these witches and warlocks are around us right now. They want your information. Why? Because they want to find out if you're connected to heirs property. So their handlers can come in and force an auction sale. That's what's going on. You got pale skins across the South who became millionaires building this type of real estate portfolio. And the guy, that lawyer talking, Thomas Mitchell, was the same brother in the video, the documentary I showed in my presentation last year. And this idiot is not telling these people, oh, this is land patents. Oh, there's thousands of cases on land patents. And we go claim that in the court. No one can touch it. But he doesn't do that because he's a damn spy. Now let's put up land patents here. State, Louisiana. Louisiana county was Bienville, right? Last name, Loud. First name, Jacob. Search. Boom, there it is, family. Look at this. There it is. Jacob Loud. Date, issue 1906. Now, just so the family can understand this, when it says it was issued 1906, that's the date. It says June 30th, 1906. That's the date the certificate, right, was issued and mailed off to him. But he actually filed the application and purchased it years before. And actually, he purchased it in 1871. Okay, that's when he purchased it, in 1871. Because when it comes to getting those patents, you have to, our ancestors actually purchased it around 7 years before, and they developed the land, they made it productive, and then after 7 years, then they make the application to get the patent, and they can show and prove that they developed the land to a point where it's productive, and then they'll get issued the land patent. But the date the patent was issued has nothing to do with the date they purchased it, because they got it around 7 years before. And in this case with Jacob Loud, he got it in 1871, and then I will show evidence of that purchase and the year, etc. Okay, so here it is here. And let's go to the patent details just to show you this here. So up top, issue date June 30th, 1906. Canceled? No. Still active, still valid. They still own the land. Now let's get a close-up look at the actual land patent. Here it is right here. Let's zoom in so the family can see it clearly, okay? Here's the homestead certificate number, 4831. This is based upon the 1862 Homestead Act that these sorcerers got you to believe that the 1862 Homestead Act were giving out the pale skins. No, it was not. Both of my patents, 1862 Homestead Act patents. I have clients with 1862 Homestead Act patents. But as long as they can get you to believe the fiction, and they'll take your stuff via forced auction. All right, let's go over this patent right here. All right, so this is the Registered Land Office at Natatoka, Louisiana, and we see this here, whereby it appears that pursuant to the Act of Congress approved May 20th, 1862, to secure homesteads and actual settlers on the public domain. And the acts supplemental thereto, the claim of Jacob Loud. All right. And then this is the land description here, section 13, township 15 north, range 8 west. Okay. And for what? How many acres, family? Containing 160 acres. And down here, now know ye that the tract of the land above described, to have and to hold to the said tract of land with the appurtenances thereof unto the said Jacob Loud, to his heirs and assigns forever. This is the superior allodial instrument. All inferior deed transactions below it means nothing. But unfortunately, the heirs do not know that. And so, based upon their ignorance, we all become food, and they got an airship racket going on, and they've been taking our land, family, via that airship racket. And no one's telling him that this is a land patent, and no one's going into court based upon that land patent claim as an heir, because there's thousands of case laws, and we're going to go over a particular case shortly. Similar situation where it was sold, but the family, once they got their hands on the actual grant, that was a case of a Spanish land grant, they went back to the court and got it. See, so when it comes to the law, you got to base everything on the law, but you got to know it to be able to base it on it, family. Never listen to these people who are trying to talk legal land patent stuff, and they don't have that knowledge, and they're not showing and proving. All right, now, I'm going to go over this document. Let me show this real quick. I got this note. This is the notebook here, which actually goes over the actual date and time, etc., of when it was purchased, okay? So you had the description of the tract, contents, rate per acre, purchase money, okay? Name of the purchaser. Let's go down here. And we see that right there, Jacob Loud, okay? See that? Jacob Loud. And we see here, roughly acres, 161 acres, roughly, okay? But now let's go to the right, and you'll know the year he actually purchased it. When was it purchased? These are the dates here. Let's go to the top, so we'll know that these dates reflect purchase dates. Date of sale, okay? Date of sale, all right? Now, so this means the date the land was sold to these individuals. And we go to where Jacob Loud is right here, right here. He purchased it when? October 3rd, 1871. Like I said, it's not the date the patent was issued, because they always purchased the land way before that. All right. And then we have here the history of it. And the first time he tried to apply for it, it was canceled in March of 1881. 7 years reinstated, May 2nd, 1890. And then here, these numbers, and it was finally approved for the patent December 11th, 1905. And then a year later, in 1906, it was issued to him via mail, the certificate, the actual patent certificate, but he actually purchased it in 1870. Right? So let me now, matter of fact, let's do this, family, because this is just a tragedy here. Let's kind of actually look at the land area here. Show the family this here, just so you can get you really know what's going on here, right? Let's go over, and then according to the description, they own the northwest quarter. Okay, they own the northwest quarter. So it was. Let's go to the patent. Go back up to the description, and it is section 13, township 15 north. Section 13. Okay, section 13, township 15 north, range 8 west, prime meridian, Louisiana to prime meridian. Let's look at this family's land here for a second, family. Right here. Prime meridian, state, Louisiana. Here, and let's take a look at it here. We'll do a quick satellite image map up and take a look at it. So here, okay, so here it is here. All right, so just to confirm what area that they own, okay, based upon the description, okay. So it says the northwest quarter of section 13, right? Northwest quarter of section 13. All right. So we have it here, section 13, township 15 north, range west. So this is, let me put this in here. Show this, show that, show that. There we go. Now let's go. Okay, so we see the yellow square is section 13. Okay. Now, northwest quarter would be here. Northwest quarter. So we draw an invisible line in the middle, right? And then a line up top, and this left northwest quarter is their section. Let's zoom in and see a little bit of it. And when we listen to the interview, family, a company called Timberland Services bought them out. Okay. And this is the section right over here, northwest quarter, right over here. And right up here. And we see there's a road, New Friendship Road, Road 571 is going through their land. Go a little closer. So we see all these trees on it, the timber, which is a precious resource. That's a very precious, valuable resource, timber, family. I went over that in my last presentation about the value of timber. And this timber company bought these, but remember, they still don't own it. The family can actually still go back and get their land there. But this just an image of their land there. And you see all those trees there, family. You see all of that. Look at that. Look at all that. Right? So, and this was fraudulently taken from them via a racket. Now, I'm going to go over this case with the family here. It's the Beggarly case, Beggarly versus the United States. Okay. United States Court of Appeals, Fifth Circuit. United States of America, the defendant, appellees. Okay. So, just to give it some background, April 3rd, 1950. Hold on one second. Hey, I'm live giving my presentation, cousin. Let me get back with you. All right. Sorry about that, family. So, April 3rd, 1950, Clark M. Beggarly Sr. bought a portion of Horn Island. Okay, and it's off it's in the Gulf of Mexico. He bought it at a tax sale in Jackson, Mississippi. On January 8th, 1971, Congress enacted legislation authorizing the Department of Interior to establish a federal park on lands that included Horn Island. In 1972, the National Park Service began negotiating with the Begley's for the purchase of their property on Horn Island. In October 1975, the Begley's entered into a contract to sell the land to the government for $156,500. Subsequently, the government canceled the contract, contending that because it had never issued a land patent, it being the United States, they were the title owner of Horn Island. And then in 1979, the United States government brought a quiet title action in the Southern District Court of Mississippi against the Begley family and other defendants. During discovery, the Begleys sought proof of their title. And then the government ostensibly conducted their search of title through the public records. And then the government then formally represented to the Begleys and the district court that no part of Horn Island had ever been granted to a private landowner. And as a result, these representations in the 1982, the government persuaded the Begleys to accept a settlement agreement. The district court entered judgment based upon that agreement, and the Begleys received $208,175.87, and title was quieted in favor of the United States. So this is very similar, family, to the Loud case. Okay, the Begleys got the land in 1950. They then had an agreement to sell it for $156,000 to the United States. Then the United States canceled and reneged on the agreement because they said, wait a minute, we never issued a land patent. Now, let me explain this quickly to the family. There's public land and private land. All public lands controlled, if it's federal public land, by the federal government, right? And then the federal government will allow the states to control public lands, and that hence they could put parks on it and have it used for public use. That's public land. But private land, family, and especially the case with land patents and land grants, when the sovereign, in this case being the United States, waive and give all of their interest, vested interest, to the individual in the form of a patent, it becomes private land, and the sovereign who gave up all of their interest and ownership and gave it to that individual, they no longer have a right. The sovereign no longer has a right to that private land. That's the law, okay? So in this case, the Begleys accepted a $208,000 payout, okay? But not over yet. They were disappointed. And so the Begleys started to actually start searching records for a land patent to support their claim of title, even after accepting it was sold and they received $208,000. So they started looking for it. They even filed a Freedom of Information Act request in Alabama, Mississippi, and Louisiana. And finally, in 1991, the Begleys hired a genealogical record specialist who conducted research in the National Archives and discovered the Boudreaux grant, which supported the Begleys' claim of title. Right? So the Begleys contacted the Bureau of Land Management requesting the issuance of a land patent for Horn Island. But the BLM summarily denied their request. So the Begleys filed another action in 1984 seeking to set aside the previous judgment, right? And so the government then immediately moved to dismiss the new lawsuit based upon failure to state a claim upon which relief can never be granted, and also based upon 12B1, which is lack of jurisdiction, no jurisdiction for the federal court to hear the case. But the Begleys filed a cross motion for summary judgment and filed an amended motion to add the Tucker Act and the Quiet Title Act as jurisdictional basis. The district court granted the government's motion to dismiss and denied the Beverly's cross motion. Right, so the Beverly's lost that case, the new case that they initiated in the district court. They lost it. So they appealed to the appellate court. So in the appellate court, the United States government tried to use the sovereign immunity to defense, and they also tried to use what's called the time barred and all of that stuff, which is what they usually use, right? So the district court, the appellate court said, we are not persuaded by the United States argument, as they tried to use the Zagura case law as a controlling case law, but it did not apply to this particular case. And then the appellate court said they conclude that the Zagura does not control in this particular action, basically, okay? So let's go over the action. So a judgment which ought not in equity and good conscience to be enforced, a good defense to the alleged cause of action on which the judgment is founded, fraud, accident, or mistake which prevented the defendant in the judgment from obtaining the benefit of his defense, the absence or fault or negligence on the part of the defendant, and absence of any adequate remedy at law. So these elements were met, right, for the Begley family, right? And so they satisfied these elements, and then the appellate court ruled that the district court was wrong in denying the Begley's lawsuit in 1994. And so they vacated the district court's order, and it was remanded. So let's go here. Okay. So it says here that the document is an English translation of a 1781 Spanish land grant, in which the Governor General of Spanish Louisiana conveyed Horn Island to Katrina Boudreaux. Although the available document is not the original grant, it is only a copy, presumably because of a fire that destroyed the Spanish West Florida archives, where the original Spanish version would have been stored. The Supreme Court has held that a certified translation of a Spanish land grant may be used to prove the existence of a grant where the original cannot be found or has been destroyed. We therefore find and conclude that the English translation is the best evidence of the original grant and is admissible to prove its existence. So, and then the court says that the land commissioner's refusal to accept the application, that's the Bureau of Land Management, that injured the Begley family. So in the end, they ruled for the Begley family. And let's get to that part real quick. So it says right here, the appellate court remanded back to the district court so that it may enter a quiet title in favor of the Begleys. All right. And the United States has option of delivering the 729 acres claimed by the Begleys, or they may pay the Begleys a new compensation based upon that particular time and that market value. But the point is this, family, even though this family originally sold and settled with the United States government because they didn't know or have evidence of the actual Spanish land grant, after that case, they did research and they found a copy of the Spanish land grant, filed a new lawsuit. Although it was dismissed in the district court, they appealed and they won the case. All right. So similarly, the Loud family, because it is a land patent that's forever to the heirs, if they go in making that particular claim, they can basically extinguish out that previous settlement agreement with that timberland company and claim their inheritance. All right, that's what they can do. So this is what I want to impress upon everyone. Family is very, very important now that we must be smarter, we must be more prudent, and we just can't start listening to what people are saying from their mouths if they've never done it. When it comes to the law stuff, they have to prove and show you their resume that they know it, the law. They've actually initiated a lawsuit, a multi-million-dollar lawsuit that they've actually won. They have the legal chops and legal knowledge to defeat experienced bar members or lawyers and judges. If they don't have that type of resume, do not listen to what's coming out of their mouth. And definitely do not give your information, because many of these individuals are on a mission to do what these pale skins are doing to many of us in the South by forcing sale auctions to take our inheritance. That's what's going on. So this is what I wanted to share with the family today. And I hope this, that we leave here and tomorrow we're smarter, we're wiser, and we're going to do our due diligence, and we're never going to accept what people say without them showing and proving. And when it comes to the law, show me your resume that you actually know the law. Because if you don't know the law and you never applied it yourself, please don't talk about the law. Please don't do that. That's how we have to be, family, to fend off the attacks from these witches and warlocks. Right? It's a tragedy what happened to this family. And this heir, the guy that was talking, called his ancestor a slave from Virginia. And oh, by the way, and that he was transported there in 1850. Let me do this before we close, because I did Jacob Lau's genealogy. All right. So here it is here. He's born around 1810 in Tennessee. Now, there's many I pulled some of the census records. Some records say he was born in Georgia. Another would say he's born in Tennessee, right? And now the reason they confuse you, family, is when you're doing your genealogy, you have to take out the valuable information. You have to confirm it, because they will intentionally, in the records, dub up the records. So especially those of us who are descendants of landlords, they're not going to make it easy for you to find your ancestor. And remember, these records were reconstructed, altered, and changed primarily after 1930. All right? But when you are chosen and selected by your ancestors will guide you to them. Right? And you'll be able to crack through all of the walls that they put up. But this particular deal, Jacob Lau, born approximately 1810. Oh, another thing, by the way, family, Jacob Lau died before that 1906 land patent was issued. He died in 1904. Okay? And we see here, dead 1904, Bienville, Louisiana. And we go down here, farmer, Bienville, Louisiana. And there's his children here. And his dad, Henderson Land, and his wife, Member. Now, remember they mentioned that in the video, in the interview. Jacob and his wife, Member. Father, Henderson Land, born 1760, Massachusetts. He died 1880 in Yazoo County, Mississippi. So he lived to be 120 years old, family. And his parents, John Land, 1743, Orange, Virginia. So when the guy in the interview, the heir, was talking about his ancestor, he thought that his ancestor, Jacob, was born in Virginia. Jacob was not born in Virginia. See, so I don't know if it sounds to me, he didn't personally do his own genealogy to go deep down his rabbit hole of his own genealogy. And then once, we have to remember, family, our own ancestors would never bless us. Once we fall victim to the slave fiction and start calling them that, you're not going to be able to find them, because they're not going to bless you. 1743 John land. We keep going back to Thomas land here. 1712 Virginia. Died in South Carolina. We can keep going back down his paternal line. 1698 Sussex, Virginia. And he died there also in Virginia. And we can keep going down here. Curtis Land, Charles City, Virginia, 1668. And we can just keep on going back, fam. But we don't need to do. I went back as far as I believe the early 1500s. But obviously, the poor current heir today has not done his own deep dive on his own history, on his paternal line. And that's sad. And then unfortunately, when you're a victim of these witches and warlock sorcery, it keeps you in a cloud of ignorance, and you become food, and hence the illegal taking of his inheritance. And he does not even know that he can get it back. And that's the sad tragedy. So we have to be careful, family. Please be careful out here. And just be smarter. And when it comes to law, you got to have them to produce their resume and show and prove. And if they don't show and prove, tell them don't talk to you about the law. You know, if they want to entertain you, and if you feel one day you want to be entertained for a couple of hours and you want to laugh, that's fine. They can do that. Maybe they're good at that. But when it comes to legal law stuff and land patents, be careful. And because, you know, there are people out here who are looking to heirs property to build their portfolio up to make millions and acquire thousands of acres via this heirship legal device. Be careful, family. And it's not heirship property. You have patented land. That's what you have to use. Start using that language now, not the heirship language, because heirs property is a target. And we just saw that with our own eyes. So thank the family. Appreciate everyone taking out their time to listen to me. And hope you found this information valuable. And we can leave here, and tomorrow we're wiser and smarter. And that's our duty. And hopefully I accomplished that today. So take care and have a good night.